Good afternoon or good morning, everyone. I'm David Glazer, and I'm just popping in for a second to welcome our special guests, Teresa and Nora, who are going to talk about how to navigate social media in the workplace. They're both employment lawyers here and help our healthcare and other clients on regular employment issues and also navigating social media minefield. As usual, just a handful of small announcements. First, your calendars carefully because our February webinar is next week. Yes, next week is still only January, but we've decided to advance the February webinar up to January 16th to cover some stuff that Congress snuck in Fiscal Cliff Bill. So the Fiscal Cliff Bill has a number of important things for healthcare, including, and this is really important, a change to the time limit for recovery of overpayments. So there's also weird stuff involving ambulance and physical therapy and other stuff, and we will cover that all same time 1 week from today. To celebrate the Webinar Listener Relief Act. That webinar is free. It's also because it'll be less valuable than the one that Teresa and Nora are about to do. Now, remember, the internet sometimes slows down over the lunch hour. If you find yourself hearing us garble, you can always dial in the number that you see in the chat box. And finally, the chat box got a little bit harder to find in our new system, but if you see in the upper right, there's a box that says chat. If you click on that, it should open up a window that would allow you to type in questions, and you can do that at any time through the webinar. Teresa and Nora are happy to entertain those. I think that covers everything I've got, so I'm going to turn it over to Teresa, who will walk you through what you need to know about social networking.
All right, so thank you so much for joining us. It has been a couple of years since we've talked to this particular audience on social media, at least in this context. And so you're probably wondering, why are we still talking about social media in the workplace? Sorry for that slight pause there. We were having technology difficulties. Surprise, surprise. Well, we are still talking about social media in the workplace in large part because we still, as employment lawyers, are receiving many questions about guidance that employers are seeking on discipline and discharge, on hiring, on monitoring of social media and other communications by employees, and daily interaction between employees and managers. And these are the issues that we are going to be talking to you about today. So why are Nora and I here talking to you? Well, I'm Teresa Thompson, and I'm a shareholder in the Employment and Labor Group. And Nora Olsen-Bluestein is here with me today, and she and I co-author the blog Networked, which is a discussion about the impact of the internet, social media, and technology, and the law on the workplace. And we've been writing on that blog for about the last
year and a half, I think, Teresa.
And we address a lot of the topics that we're going to talk about today. So if you don't get answers to all of the questions that you have, you can take a look through the blog and probably find some of the answers that you might need to your questions. And Nora and I do a lot of speaking on social media. We do a lot of training, and we talk to our clients all of the time about how social media impacts the workplace. And we hope to impart some of that knowledge to you today.
Great, so let's get started on the meat of our presentation here. We're going to talk first about discipline and discharge for employee social media activity. This is a really hot issue right now, and I'm sure many of you who have dealt with this have thought to yourself, I can fire my employee for his comments, right? Well, I would advise you to first step and do some analysis first, because if you just take action right away without doing a little bit of analysis, you may end up in some hot water.
And just so all of you know, this is something that probably 3 years ago, clients would call and say, I just fired my employee for this Facebook post. Is that okay? And some of the things we're going to talk about here today will explain why the law is changing and how it is changing and why that decision is not.
So the first thing to do if you're faced with an employee Facebook or other social media post that makes you want to fire the person is to think about what kind of laws might come into play. A big one that we're seeing right now, which we did not really deal with much at all a few years ago, is the National Labor Relations Act. This act people commonly associate with labor unions and organizing activities, but Section 7 applies to both union and non-union workforces. Section 7 protects employees who are joining together to discuss their terms and conditions of employment and try to take action, join a common cause. What you need to remember with protected concerted activity, though, is not all activity is protected and not all activity is concerted. So we're going to talk about this and explain it in more detail in a few minutes to see how this plays into social media posts, but it is one law that could apply. We'll also talk about how the National Labor Relations Act can be violated just by virtue of overbroad employee policies. That is a really hot issue right now. The National Labor Relations Board, when they're dealing with these cases, they scour employers' policies, not only social media policies, but a number of other policies, to see if those policies violate the act as well.
And just when you're thinking about the National Labor Relations Act, when we're talking about terms and conditions of employment, what non-union workforces were traditionally dealing with were things like, can employees talk about salary or compensation, and can we prohibit them from doing that? They've never had to deal with these sorts of issues that we'll talk about today.
Some other laws that might come into play if you're thinking about terminating an employee for social media posts are things like state whistleblower laws. There are some federal whistleblower laws as well. This might come into play, for example, if an employee is posting and complaining that the company is violating the law in some way. That would not be a real great post to have out there on the internet for the company's reputation, so it might get the employee in trouble. However, if you end up terminating an employee because of that post, and that post is protected by a whistleblower law, the termination could be unlawful. Similarly, we have civil rights laws, both state and federal, that protect discrimination, prohibit discrimination, harassment, and retaliation. Those laws could come into play if the posts are, again, complaining about harassment or discrimination, or if somehow a person's protected class status comes into play, like their gender, sexual orientation, race, etc. We also need to consider privacy rights because, as you know, a lot of social media is public, but there are things that are behind privacy settings, and to the extent we're getting at information that's not available to the public, an employee's privacy rights might come into play.
So you're probably wondering, can I fire anybody for their postings on social media? Well, during the course of our discussion, we will give you some sort of hands-down rights to be able to continue to terminate if your employees are acting badly on social media. And this one, for our healthcare clients, is a big one, which is what happens when an employee posts pictures of patients or other data on social media sites that are protected, for example, by HIPAA or other patient privacy rights or statutes. You can still fire your employees if they take a picture of your patient and post it on a Facebook page or a MySpace page, as happened in this particular incident. But one thing that you might want to consider is whether or not you have a policy in place that actually addresses this particular thing. And I know Nora and I both recommend for our healthcare clients that you very specifically have a cell phone policy that talks about having your cell phone on your person and prohibiting taking pictures of patients or patient information and posting them on social media sites. And you would think you wouldn't have to provide that much detail to your employees. You would think it would make sense to not do that. But both your staff people as well as your doctors have been terminated and have taken action to post patient information on social media sites. So this isn't just your staff, it's also doctors who have been found to violate HIPAA and other policies of the employer. In this particular circumstance, a Rhode Island doctor actually went home after a bad day at the ER, posted enough information on a Facebook page to actually identify the patient. And as a result, this particular doctor lost her job and lost all of her privileges at the hospital. And this was just one post. So again, what we recommend with regard to posting very protected information is to make sure that you've done some training and you have a policy that outlines that this type of conduct is prohibited. But if your employee goes ahead and does it anyways, whether it's a doctor or a staffer or anybody else, you can fire them.
So now we're going to go into some examples, circling back to the National Labor Relations Act, and how that act plays out in real cases. So here we have the case of the bad hair day. This employee was terminated because she was taking pictures of coworkers who were violating the dress code policy. She had gotten in trouble for wearing a hat to work, but she'd worn the hat because she had a terrible haircut, apparently. She complained about that. She thought that the policy was being unfairly policed, that other coworkers wore hats to work and didn't get into trouble. So she started taking pictures of her coworkers to show that the policy wasn't being enforced across the board. She was terminated for violating the company's no photo policy, interestingly, which we were just talking about. And then she brought an unfair labor practice charge under the National Labor Relations Act. Now, this isn't technically a social media case because she didn't post the pictures to any social media sites, although I think that may have been because the case originated a few years ago. I can't imagine now that the pictures wouldn't be somewhere online. But in this case, the termination ended up being unlawful because it violated the National Labor Relations Act. The Fourth Circuit found that the employee, her conduct was protected concerted activity because she was joining together with other employees to protest a company policy, and she was terminated for it. One other note for this case, which is interesting, is the no photo policy. It was the first time the company had decided to enforce the policy. Now, whenever you're enforcing a policy for the first time, and it's not a brand new policy, that should be a red flag that you're not being consistent in your enforcement of policies, and that often can lead to trouble. Another case is a LinkedIn case where a not tech-savvy employee posted on LinkedIn that his job position was, as you can see on the screen, a bad word. That post lived on LinkedIn. His position title there lived on LinkedIn for quite a while, and the employer didn't know about it. A couple years later, he was complaining to coworkers about overtime. So that would be discussing terms and conditions of work, but the employer also didn't know about that. However, right around the same time, they found this post, terminated the guy for his bad judgment and because the post violated their policy that forbids posting information that's obscene, defamatory, harassing, or abusive. But he brought that unfair labor practice charge because of his complaints about overtime. Not being paid overtime. This charge ended up being dismissed because the company was able to show they didn't know about the protected activity, which would be complaining about overtime, not posting that your job position is, as you can see on the screen.
And one of the hard things about these kinds of cases is that timing piece. So here the case turned on the timing because they didn't know about the protected activity. But when you do have unprotected conduct like what is posted on your screen and protected conduct in the same area, it could very likely result in legal action against you because the employee will think, well, of course they knew about my protected conduct. So again, when you're faced with this kind of a circumstance, it's always good to think twice and to sit back before you take legal action. Now, we do have a quick question I'm going to answer. Which was whether or not the NLRA applies to all organizations, that is, to all clinics and hospitals. And the answer to that question is yes. The NLRA's provisions related to protecting employees from engaging in protected concerted activity apply to every organization, not just union employers.
Another recent case that has come out from the National Labor Relations Board is what we like to call the BMW hot dog case. This case is really interesting because some of what the employee did was protected, some of what he did was not. So there were two things going on. First, the employee worked at a BMW dealership, and they were having what was supposed to be a high-end event, and he was upset because they were serving hot dogs and potato chips. And he was worried that this would negatively affect his ability to earn commissions because customers would not be impressed by this event. So he posted on Facebook snide comments about the chips and took pictures of coworkers holding hot dogs and things like that. Around the same time, at an adjacent car dealership that was owned by the same company, a teenager, I think it was, a 13-year-old, drove a Land Rover over an employee's foot and into a pond. And the employee who complained about the hot dogs also took pictures of this and made snide remarks about that. So he was, not surprisingly, terminated and brought an unfair labor practice charge. Now, the National Labor Relations Board ultimately found that the hot dog comments were protected because coworkers were responding to the post, so we get this concerted activity, and the comments were protected because they related to the terms and conditions of employment because he was worried about his sales commissions. The posts about the Land Rover and the car accident were not protected because it didn't relate in any way to his employment. So luckily for the employer, they were able to convince the board that, and the administrative law judge, that he was actually fired because of the Land Rover comments, not the hot dog comments. Lucky for them, I guess. This case went all the way up to the board, and they affirmed the ALJ decision. What's also interesting about this case, and we'll talk about it in a minute, the board looked very closely at the dealership's policies and found that some of those policies were unlawful because they chilled employees' ability to go and engage in this protected concerted activity. So we'll get to that in a little bit when we're into the more practical part of the presentation about what you should do when you're faced with these situations.
So you're probably wondering at this point, every time that I take action against an employee for a Facebook post, am I going to be sued? Well, I'm happy to say that while this probably isn't likely to occur in a healthcare setting, you never know. Your employees may exercise some bad discretion and take off their clothes and decide to bathe in some manner in the sinks at your work site, as these fast food employees did in this circumstance. I am confident that, at least to date, we have not seen any charges coming through the National Labor Relations Board or other based upon terminations for bathing in sinks at work, as these employees did. So let's talk a little bit more. This is another National Labor Relations Board case. This involved a saloon and eatery, and this was a discussion between a stepsister and a bartender who worked for this particular employer. He was complaining about not having a raise. He was doing waitress's work without tips. He thought his customers were rednecks, and he also hoped that his customers would choke on glass as they drove home drunk. Well, again, without surprise, this particular employee was fired when the employer found out about these comments, and he brought a National Labor Relations Act claim against the employer. Well, in this case, we look at these complaints and we say, well, this kind of looks like talking about terms and conditions of employment. Certainly the talking about the raise and doing waitress's work, but he also is, if not threatening his customers, he's certainly making derogatory comments about his customers, and he's also making comments about sending his customers home drunk. So we've got a real mix of comments. The ALJ in this particular case didn't actually rule on that part of it, which is unfortunate for us because as lawyers, we like to see how those things play out when you've got both protected and unprotected comments. But in this case, the ALJ ruled that because these comments were solely between the stepsister and the bartender, that there was no concerted activity. So one of the things we always look at is whether or not the posts are actually being exchanged between employees of the company. And in this particular case, since there was no other employee involved, the posts were not protected, and this termination was upheld.
The Hispanics United case was just affirmed by the board a few weeks ago. In this case, employees were posting on Facebook complaining about a coworker and criticizing her and making nasty comments. This coworker was critical of one of the employees' job performance. So there's this banter on Facebook that you can read here on the slide. The employee who was critical of her coworker's job performance sort of implied that she was going to go to management after she saw this. Management sees the posts and terminates all the employees who were posting because they felt that the posts violated the company's anti-bullying and anti-harassment policy. This ended up with another unfair labor practice charge, and the terminations were found to be unlawful because they were protected concerted activity. Now, what's unusual about this case is that here it's not coworkers complaining about a supervisor or company policy. They're complaining about a coworker. Typically, that's not protected. But what the board found was that they were complaining about the coworker who was critical of their job performance, and that by itself implicated the terms and conditions of employment, and then the comments were protected. This case, Teresa and I think, is a bit of a stretch, and kind of drives me crazy because the company had legitimate reasons. I don't know if the employees needed to be terminated, but to deal with employees who were harassing another employee online.
There actually is, in our view, there's a real problem with this particular case, and we've had this debate now internally in our department for the last year since the original decision came out, and that is what happens when you've got somebody that probably is violating the harassment policies or the bullying policies, and how do you deal with an unfair labor practice charge when you've also got violations of your harassment policy? How can you enforce one without the other? So again, I think that the one thing we really need to stress here is that you can't simply say, this does violate our policy, therefore we're going to terminate. You really do need to take into consideration the broader picture now.
Now here we have an example that should hit close to home for many of you. There was another NLRA case where an employee was posting comments about the vulnerable adults for whom she was providing services. So she is posting on Facebook and discussing with a friend of hers these posts that you can read. She's talking about one of her clients who's laughing, and she says, I don't know if she's laughing at me, with me, or at her voices, not that it matters, good to laugh, and talks about putting people in straitjackets and things like that. A little bit more information about clients than I would like seen posted, especially when you're dealing with vulnerable adults here. So this employee was terminated for her comments, brought the unfair labor practice charge, but ultimately the employer won in this case because, as in that saloon case, she was not posting with friends, or with other employees. She was posting and a friend was responding. The ALJ may have thought things were different if there were employees responding. Now that would have been a more interesting case because then maybe we would have gotten at the HIPAA and privacy issues, because then we would have two employees perhaps giving enough information that the consumers would be identified. It's hard to say. We're very happy in this case that the termination was upheld.
And one of the things here is that this particular employee was actually friends on Facebook with a former client. And so the former client is the one that brought this to the attention of the employer. And I think that too must have had an impact because the comments made were not particularly respectful to the client. And I think that assisted the employer in defending this particular charge.
Now, a separate issue is why this employee was friends on Facebook with clients, but we'll talk about that toward the end of our talk today.
So we've talked a little bit now about we've got inappropriate posts, we've got sort of snide comments, we have some disrespectful comments made about clients. So what happens when you've got threatening or rageful statements about the workplace? I know that this is always a big concern because employers don't feel like they should or that they can simply ignore comments that are threatening violence to another employee or to a client or to a patient. So let's just say another employee brings in a post and they say, hey, this bothers me, I don't know what to do. So how do you respond? Thankfully, here in Minnesota, we do have a little bit of response from our Court of Appeals as to whether or not you can act based upon policies and procedures that you have in place if an employee is threatening another employee or a client or a patient or a customer. So let's look at that particular case because the posts there were a little bit frightening, at least to the people involved in this case. Here, the posts involved a student at the University of Minnesota who is actually working in the embalming lab, and the comments made related to wanting to stab somebody in the throat with a trocar. A trocar is a long, skinny knife that they use when working in the lab. And she talks about updating a death list. She also made some disrespectful comments regarding the cadaver that she was working on. She had named him Bernie in reference to A Weekend with Bernie. And said he won't be with me anymore. I wish to accompany him. I'm going to take a lock of his hair and put it in my pocket. And frankly, it's just a little disgusting when you think about it. But nonetheless, the University of Minnesota was presented these posts by the student because students and professors were friends with this individual on Facebook, and both the students and the professors were a little bit frightened by the posts. The student responded that this is just sarcasm. Everybody who knows me knows that I'm simply being sarcastic. This is just my sense of humor. How could anybody think that I was serious? And yet people did think she was serious. So this student was disciplined pursuant to the policies of the University of Minnesota. We find this particular case important to the employment setting because we are constantly telling our clients, put the policies and procedures in place so that if you want to prevent certain conduct like this, that you can go back to the policy and enforce your policy and take disciplinary action or terminate an employee based upon those. The University of Minnesota did take disciplinary action against this particular student. It went up to the Court of Appeals and then went up to the Supreme Court. And in the end, the discipline was upheld because both the Court of Appeals and the Supreme Court determined that the University of Minnesota should not have to ignore threatening comments made by a student. And I would say that that is good guidance for us in the employment world to be able to say that if threatening comments are made, it will not be protected conduct. Might not mean that you aren't landed in a lawsuit that takes you to the Supreme Court, but you should be able to rely upon those policies. This also happens in the context of people really making other offhand remarks. This particular case involved a professor who was suspended for making comments on a Facebook page. And what did she say? She was asking whether anybody knew they could find a discreet hitman. Yes, it's been that kind of day. She posted 1 month later that I had a good day today, didn't want to kill even one student. Now, Friday was a different story. So here we now have a professor, and this could easily be a doctor, this could be a nurse, this could be anybody within your organization going home and venting about their day. This is something that I see my friends on Facebook doing all the time. And the question is, in this particular circumstance, was this person being serious? Should the employer have terminated or disciplined the professor for making these posts? In my view, yes. Professors shouldn't be making these posts, doctors shouldn't be making these posts, and neither should any of your other employees. But to me, and in this particular case, I think the suspension was reversed. There were enough people who knew that this professor was kidding. Nobody took her seriously, and so there was a different case, a different circumstance and different reaction to these particular posts. In my view, when we're looking at these kinds of posts which might be considered threatening, the best way to deal with these is to get that person in a room, have a positive discussion with them, find out what's going on, and probably prior to that time, make sure that you've engaged in some kind of training relating to social media posts, their impact on others, and particularly posts that relate in some way to harming other people and how that might be taken by other people online. Because the one thing that we have found out through all of these cases is that sarcasm does not come through very well online. It's no different than email communications or other online communications. People never know what is in your head. And so some of these things could have been probably avoided had the employer engaged in some kind of training to tell people you shouldn't be doing these things. And I always say that employees really should know about that, but you would be amazed at what I see on a daily basis being posted on Facebook that is probably inappropriate and might be taken the wrong way if you happen to be friends with people you work with.
So we've just run through a number of examples of real cases that each have different facts, and the facts really determine how things turn out. But let's see if we can digest this into a few takeaways. So first, when you're faced with posts that are may lead to an employee being terminated, let's look at the facts. Look at the facts about what was going on. One thing to look at is what were the expectations of the employees. So if we're dealing with the National Labor Relations Act, were the employees who are posting talking about anything that could be construed as involving the terms and conditions of employment? And you've seen how broadly that can be interpreted in some of the cases we talked about. Were there any indications in the posts that the employees were going to do something about their complaints? That's important. They need to be getting ready to take some kind of action. That distinguishes things from just comments that are just venting. I would say that it can be difficult to decide whether a post is just venting or whether there's really a call for action, and that may just come down to the particular judge you're in front of, which isn't a great response. But look at that. Are they trying to take some action? Then focus on the interactions between employees. First of all, are there any interactions between employees? If this is just one employee out there posting, nobody's responding, or the people responding are not other employees, then you're not going to have that concerted element that you need for protected concerted activity.
Although I just want to jump in there for a second, there has been some question as to whether or not if another employee likes the post, whether liking a post in and of itself is going to be protected concerted or to make it concerted activity. And I think there's also a question if the employee is friends with other employees so that other employees read the posts, even if they don't respond to the posts, that there may be some kind of concerted activity because maybe it sparks a later discussion. So I always caution that you shouldn't look just at the Facebook post, that it warrants a further investigation to be able to determine whether that sparked another interaction.
That's right. It's a really good point to remember to look not only at the online conduct, but how that then spills over into real life. So those are things to look at when you're looking at the discipline discharge decisions. As I mentioned before, policies are also going to come into play if you end up before the National Labor Relations Board. In the BMW case, one of the policies at issue was a courtesy policy that talked about employees should always be courteous and not disrespectful. There was another case, the Costco case, which we didn't talk about because it's not really a social media case, but a policy that was found unlawful was something that has been very common, which is policies that prohibit employees from making defamatory, derogatory, disrespectful comments. The National Labor Relations Board has taken a position that that kind of policy is overbroad and unlawful. I see that language all the time. So it's worth looking back at through your employee handbook and manual to see if you have policies like conduct policies, social media policies, computer policies, other things that have that language in it. It's time to update it.
Confidentiality policies, too, have come under fire by the NLRB, and so you might think that your confidentiality policies are safe, but sometimes there's overbroad language in the confidentiality policies, and so policies that even 6 months ago we might have told you, hey, this is probably okay, based upon this very recent guidance by the NLRB, I would say that's probably not true.
And one thing you can do to supposedly protect yourself is including a disclaimer in your handbook or in the applicable policy that nothing in this policy is intended to, for example, prohibit employees' rights to discuss the terms and conditions of employment. That comes from guidance we've received. However, none of the cases discussing this have upheld any disclaimers that employers have tried to use. So it's a good thing to try to do, but whether that will save you if you've got overbroad policies is somewhat doubtful.
So the only thing that I would also add is that when you're doing that original analysis of the employee conduct to determine whether discipline or discharge is appropriate, you should also be looking at, is there other conduct that trumps the protective concerted activity? And this isn't a decision that I would want employers necessarily to be making without legal counsel, but when you've got threatening, rageful, disrespectful conduct perhaps toward clients, that type of conduct might actually trump the protected conduct and still give you the right to discipline or discharge based on other policies. So there is still a way out in certain circumstances if the conduct is bad.
So let's shift to the beginning of the employment relationship and how social media impacts that. A big question that we get a lot is, can we vet applicants using social media? The number of organizations doing this has increased exponentially in the last several years. So we used to be asked, is it a good idea to do this? Now it's more about, we're doing this, what should we and should we not be doing? So again, what we want to think about are laws that come into play and best practices. Privacy issues are a big one when vetting applicants through social media. Here's Facebook's Mark Zuckerberg saying privacy is no longer a social norm. I tend to agree with that, with how much people overshare on the internet. But there is pushback to that, and there are still privacy settings that you can put into place to protect your information. And so there is a line that does protect private information. And some employers, in an effort to vet their applicants very thoroughly, have crossed that line and gotten into trouble. So when you're thinking about privacy concerns with vetting applicants on social media, think about whether the information is public or private. How do you figure that out? Well, public information is something you could find on a Google search or just a general Facebook search where you're not putting in password information or paying for the information. On Facebook, it would be what's open to a general user. It's not something where you've had to friend the person in order to see it. When you start doing things like that, then you're crossing over into information that might be considered private. And while there is no overarching law that specifically controls social networking, we are seeing a number of different laws coming into play when you're looking at private information. A big one is the Federal Electronic Communications Privacy Act. That has two portions to it. One is the Wiretap Act, which in very general terms prohibits what you would think of as wiretapping, so intercepting messages sort of in real time. And the other part is the Stored Communications Act. This is the one that will come into play with social media cases. This is where you're unlawfully accessing information stored online.
So you may wonder why these laws are particularly important to any of you, and the reason is because we are seeing more lawsuits now being brought because of access to some of this potentially private information. Now, one of the things that we saw about a year and a half ago, right about the time we started the blog actually, was a concern brought by an employee of the Maryland Department of Corrections, because during the application process, the interviewers required the applicant to log on to the Facebook account so that the interviewer could read the postings, along with those of all of his family and friends. There were a number of different organizations that objected to this, and the employee ultimately sued, alleging violations of the Stored Communications Act, among other laws. And the important part here is that this prompted a nationwide debate over whether or not employers should be permitted during the application process, the hiring process, or the employment relationship to be permitted to ask for social media passwords. Now, this debate started, you can see I wrote about this back in April of 2012, but this started before then, and during 2012, California, Maryland, and Illinois all enacted legislation that would prohibit employers from requesting or requiring an employee or applicant to disclose a username or password for a personal social media account. Some others, at least 14 other states, introduced legislation in 2012 which would restrict employers from requesting access to social networking sites. And Minnesota is one of those states. And so I expect to see in 2013 a number of other states, and possibly even the federal government, enacting legislation to protect employers' private or employees' private information that they have protected by appropriate privacy settings. And some of the legislation, and I think that this is important, also sort of rolls over into asking for information or asking somebody else to give you information that is behind a privacy setting. And that might ultimately also tip over into whether or not an employer can ask another employee to provide that information, and whether or not that would violate these particular statutes. So I think there is some concern that these statutes will ultimately impact the ability of employers to gain information from social networking sites.
Some other laws that come into play when you're vetting applicants on social media are the civil rights laws, state and federal again. These come into play because when you're using social media to vet applicants, you're learning potentially a lot more protected class information than you might otherwise learn, especially early on in the process before you have an interview with somebody. For example, take somebody who doesn't use privacy settings on their social media accounts. So you do your general searching and you're exposed to this person's entire personal life. You see their picture, so you know their race, their gender, a rough idea of their age. You read some of the comments, you find out that the person has certain religious beliefs, has a certain sexual orientation. This is much more information than you would otherwise learn. And if you end up not hiring the person, there is a potential that the employee claims that, or the applicant claims that he or she was not hired because of information that you learned on social media. There's also some concern with the demographics of social media sites. although this may start to even out as more and more people are on social media. Now, when you're thinking about demographics, you might initially just think of age, but we're not talking so much age, but what about race and ethnicity? We have some statistics on LinkedIn that show that it is the vast majority of users on LinkedIn are white. So if you're only searching for your applicants on LinkedIn, you're missing out on a large number of people of color, and there's some potential there that you could end up in a lawsuit for some kind of disparate impact. So a takeaway on the human rights concerns is something we got from the Equal Employment Opportunity Commission, who talked to the New York Times about the topic. Just remember that things you can't ask in an interview are the same things you can't research. You've all been trained and are very knowledgeable on interview questions, things you can ask, things you can't ask, things you can and can't have in your employment application. So take those best practices and apply those when you're looking on social media. Some more laws that come into play again are HIPAA and also GINA, but here it's not so much employees who are disclosing your patient's information online, but it's more you're accessing their social media accounts and learning their medical or genetic information. GINA is a big one because genetic information is defined really broadly and includes family health history. So you could easily envision a situation where a person is posting on Facebook about a serious illness that a family member has. And if you decide not to hire the person because, for example, you're worried that somehow they won't be able to work because they're going to need all this time off to take care of their ill family member, perhaps you've made your decision based on genetic information in violation of GINA.
So what are some of those strategies then, since we know that people are going to vet their applicants via social media, even if we tell them that they should not? What should you be doing? Well, we've come up with our best case scenario and our best practices, and these have not necessarily been tested yet by the courts, but at least based upon what we see now, this is our best guidance we can give you. You should establish some guidelines and procedures. You should decide what media you will access. Do you go to Facebook if you've got the opportunity, or do you avoid it? What specific searches will you make? What questions are you going to ask? Who's going to conduct those searches? You should really think about designating an individual outside of the hiring decision-making who is going to conduct those decisions. And then once you actually conduct those searches, make sure that you determine what information is going to be recorded in the application process. Because let's say that you have this individual conducting these searches and they come across some information that they shouldn't have, or that you wouldn't normally consider or are prohibited from considering in the hiring process, you simply don't record that information. And once you do record the information, who are you going to give access? Are you going to limit the access to the information that you found on social media? And in the same context, what information are you going to permit the decision makers to use when making those decisions? Now, when we give these best practices and we talk about designating that individual without the hiring authority to conduct the searches, I have to step back a little bit, because most of the time that's going to be somebody who is sitting in Office A, which is right next to Office B, and the person in Office B is the one who is making the hiring decisions. And sometimes the information that you might find on social media is just so juicy that you just can't help it. You got to share it with that other person. And so we all know human nature, and there is some there's some ability or inability of people to kind of hold that information back. So if you put these procedures in place, make sure that you've got somebody that you can trust who is going to say, okay, we're not even marking that down. I'm not taking a screenshot. I'm not taking it any further. And we are not going to let the decision makers actually see this information. And again, we're not certain how this approach is going to work with the EEOC or other agencies, but it is the best practice we can provide so far.
And the whole point of it is to be able to show, if you end up having your system challenged, that you crafted a well thought out policy or plan for doing this, that you applied it consistently, and basically that you were doing your best to keep that protected class information out of the process, and that's your best defense. Something else to think about when vetting applicants on social media is the Fair Credit Reporting Act. One way to outsource your social media checks is to just have a background check company do it. There are also a new industry of companies who are specifically doing social media background checks. And that's great. That might be what works for your organization. But I would remind you that whenever you're having a third party collect background information and you're paying them for it, the Fair Credit Reporting Act is going to apply. That means that you need to comply with certain consent and notice requirements, giving the right disclosure information to the applicant, obtaining their consent for the background check, and also remember there are state versions of the Fair Credit Reporting Act that have their own unique idiosyncrasies that you need to make sure you follow. Social intelligence, just briefly, was really interesting. They were interviewed by the New York Times. They were looked at by the Federal Trade Commission, which used to regulate the Fair Credit Reporting Act, and they were essentially given the okay because they were complying with what they needed to do. But they will collect an entire portfolio sort of on whoever the applicant is with all of their social media activity. But they also screen out the protected class information. So they block out skin color and delete, redact out posts that might disclose protected information.
And just one more comment that a law that we didn't talk about just because of our picture here about individuals drinking. Many states have lawful consumable products laws that protect employees from engaging in lawful conduct outside of the workplace, such as drinking or smoking, and it prohibits an employer's ability to take legal or take disciplinary or discharge action based upon that conduct, that legal conduct outside of the workplace. And so if you obtained information like that from either an outside agency or your own social media check, you cannot, in those states with those laws, take action based on that. So we've now talked about the discipline and discharge process. We've talked about the hiring process. We're going to touch just briefly on monitoring. And this relates both to email communications and to social media activity. And you might wonder why, in this context, we're actually talking about this, but it's because this issue has been coming up much more commonly recently in a very similar situation to this one. For example, you've got an employee who is either getting ready to quit or perhaps isn't performing to standards. You're wondering if they're going to leave the company, engage in a competing business, or maybe they're unhappy, so you want to monitor activity on the computer, personal webmail, social media pages, or a smartphone. So what do you need to take into consideration? Well, first of all, the same laws that apply to protect other communications apply to this type of monitoring. So you need to look at the Electronic Communications Privacy Act that we've already talked about. There has been some direction by the United States Supreme Court on monitoring of employee communications. Unfortunately, in the Kwan versus Arch Wireless case, the Supreme Court did not give us the direction that we had hoped that it would. And in fact, because of the ever-changing landscape of the technology, the Supreme Court said that we will not resolve the disagreement over an employee's privacy expectation because we don't know how workplace norms and the law's treatment of them will evolve. And we were hoping that the U.S. Supreme Court would actually provide that guidance, but they did not. And so we have privacy concerns both based on federal statutes and federal law in monitoring. So when does this come into play? Some of the guidance that we have received relates to, for example, an employer's desire to find out what its employees have done on private chat rooms. So in this particular case, a group of employees had created a MySpace group to vent about their employer, and that's all they did. They went on the site and they vented about everything, but they had it protected by a password. Only employees were permitted access, and an employee, the employer found out about it though, and asked a trusted employee to give the manager access to the site. What happened is the employer went on the site, fired all of the employees who were posting there, and those employees sued. And they prevailed, and a jury found there was a violation of the Stored Communications Act because the employer's monitoring and viewing of that particular private chat room violated the Stored Communications Act. Now, this is important because the employee testified that she didn't feel she could refuse the employer, so that consent given to access the site was, in the court's mind, coerced. And so this goes back to not asking somebody else to give you access to what you would not otherwise have access to. This goes also to whether or not you can access personal emails of a former employee simply because the employee has left that information on the company's systems. Now, there have been cases, and these are mixed throughout the United States, about whether you should access employees' personal email accounts, and this would go to private social media sites as well. And the very general answer to that question is that if you did not have consent from the employee to access that site, you should not be accessing it simply because the information, a username or password, was left on your system. Now, there may be exceptions to that, and there certainly would be if you suspected them of taking confidential trade secret information or something along those lines, but your best bet in those circumstances is to go through the courts.
So how do you avoid ending up in hot water for a Stored Communications Act violation? Have a policy in place that you've notified your employees that you can and will monitor, that they have no expectation of privacy, and get their consent by getting them to sign off on the policy. Take a look. If you don't have a policy, you need one, or don't think you can monitor, is essentially the blunt answer. But even if you have a policy, look at it. It needs to be updated if it's been more than 6 months or a year. Technology changes, so you need to keep on top of these policies. If you're going to monitor, you also need to have a legitimate business reason for doing it. You don't want to just pick and choose who you're monitoring and not do it because you have or do it even though you have no reason. And also be careful if what you're monitoring, if you run across truly private communications, like between a husband and wife where they're discussing their personal matters, or if you find an employee talking with an attorney. And then quickly, just to wrap things up, what about who you should friend on social media? Should you friend your boss, your subordinates, your patients? You know, each organization is different, but the risk with friending any of these people is you're going to learn way too much information. If you're a manager, you're going to learn too much about your subordinates, and you need to think about what you will do with that information. You might learn things that raise concerns about harassment or discrimination, and then what do you do with that information? With patients, you may be crossing boundary lines, and being friends with these individuals may be fine until something bad happens, and then it's just a very awkward situation. So remember, if you are friends with any of these people, that your workplace code of conduct policies apply to your social media interactions as well, just like they do in face-to-face conduct. And also remember, as we've said a couple times now, you can't use information you learned on social media if you wouldn't have otherwise had access to it. And if you don't want to deal with the problems involved with friending your subordinates or your patients, then look at your policies. Consider adopting policies that give guidance to employees about who they can and can't friend on social media, and explain why you're making those decisions.
And for our healthcare clients, this is particularly important because more and more patients and doctors and nurses, etc., they have a long-standing relationship, and it's a natural thing to say, hey, I'm going to friend them on Facebook. But there is a real concern with that. And so we are often recommending anyways that you look at your social media policies and make sure that you have a specific provision that addresses your friending policy. Because one of the things we find regularly is that you don't know who your friends are. And friends needs to be in quotations, because most of the information that we see that comes across our desk is because one of your friends, in quotations, on Facebook printed it out and brought it to the supervisor or to the HR professional and said, hey, this is conduct that I don't think should be happening. So everybody should have that in mind when they're interacting with people from work on social media. And so we've covered a lot here today. We thank you for participating with us here today. We hope you've taken away some good tidbits. And if you've got any questions, you can always submit them to us at this contact information. And once again, thanks so much.
Thank you.